themselves are not here,
Okay.
my lord. Yes, my lord.
Appearance.
Most respectfully,
Appearance.
yes, my lord. Most respectfully, my lord.
Yes.
Ekene Madwaguna.
Ekenema Dwaguna.
Yes, my lord.
Yes.
My lord, I appear for the defendant, and Chris Ekong appears with me, sir.
Chris Ekon.
Yes, my lord.
Where is Chris Ekon? I can't see him. And okay. Yes, yes, I have seen you. Yes, any other appearance? Any other appearance? No appearance for the claimant.
The claimant is here, my lord.
I have to see your appearance before I record you present. Where is your counsel?
I was the one that sent the notice. I expected you.
This matter is for judgment. This is the judgment of the court. On the 3rd of November 2023, the claimant took out a general form of complaint accompanied by a statement of facts, witness statement on oath, list of witnesses, list of documents, and photocopies of documents to be tendered as exhibit at the trial. By the paragraph 4 of the statement of facts, the claimant prays for the following reliefs. They are: 1. A declaration that there exists an employment relationship between claimant and defendant between 3rd day of June 2013 till 4th day of May 2023, where the claimant served as mechanical instructor, lecturer 2, and rector stroke principal lecturer respectively at the Unicam Community Initiative UCDI Training Institute. 2. A declaration that the offers of appointment of December 15, 2014 as lecturer 2 and July 16, 2018 as rector principal lecturer 2 issued by the defendant at the Unicam Community Development Initiative Training Institute are all valid employment offers and same have been accepted by the claimant with their effective dates. 3. A declaration that the refusal of the defendant to pay all remuneration and other benefits accrued to the offers of appointment of December 15, 2014 as lecturer 2 and July 16, 2018 as rector stroke principal lecturer at Unicam Community Development Institute Training Institute as issued by the defendant is unlawful, null and void, and of no effect whatsoever. 4. A declaration that by the offer of appointment of December 15, 2014 as a lecturer 2 and July 16, 2018 as a rector principal lecturer by the defendant at the Unicam Community Development Initiative Institute, the claimant is entitled to all remuneration and other benefit attached to the status of employment. 5. An order directing the defendant to pay the sum of 51,009,750 naira as his basic salary and 38,436 naira 801 kobo 801 naira for allowances due to the claimant from 15th day of December 2014 till May 2023. 6. An order directing the defendant to issue a certificate of service to the claimant for rector as appropriate to his last service to the defendant. 7. An order directing the defendant to pay the claimant the sum of 10 million naira as general damages for hardship, embarrassment, pain, and suffering. An order directing the defendant to pay the claimant the sum of 10 million naira as special damages. An order directing the defendant to pay the claimant a post-judgment interest of 10% per annum on the total judgment sum due to the claimant from the date of judgment until judgment debt is paid in full. And lastly, cost of litigation in the sum of 1 million naira. In reaction to the originating processes commencing the suit, the defendant on its part filed a statement of defense dated 20th day of May 2024, but deemed properly filed and served on the 21st day of May 2024 by order of court. In the statement of defense, it was averred, among other things, that the claimant is not entitled to the relief being sought. Consequently, this honorable court was invited to dismiss the action against the defendant as same is unfounded and devoid of merit. The claimant testified in proof of his case as CW1. CW1 adopted his witness statement of oath and also tendered Exhibit C1 to 14 in evidence. Exhibits X, XX1, XX2, and XX3A and XX3B were also tendered under cross-examination through CW1. CW1, at the end of his evidence in chief and cross-examination, was discharged. However, following the filing of reply to the statement of defense, CW1 was recalled. At the recall trial, CW1 adopted his witness statement on oath, filed along with the reply to the statement of defense as his evidence. Respecting the reply to the statement of defense, two documents were tentatively admitted in evidence as Exhibit CR1 and CR2 respectively, and counsel were allowed to address the court on their admissibility in their final addresses. However, counsel seems to have abandoned his objection because there was no such objection raised in the final written address. CW1 was cross-examined. The second was cross-examined after the adoption of his witness statement on oath filed a reply to the statement of defense. Thereafter, he was discharged. The defendant called one Baron Ita, a member of staff of the defendant, who testified as DW1. DW1, after adopting her witness statement on oath, tendered document in evidence, which were admitted as and marked as Exhibit D1, D2, D3, and D3. DW1 was, after being cross-examined by counsel for the claimant, discharged. At the close of the defense, parties were ordered to file their final written addresses, which were adopted by the counsel. The case of the claimant. Counsel, I'm having kata, so I will skip reading the case of the claimant. I will also skip reading the case of the defendant. I will also skip the reply to statement of defense. There is also the submissions of the defendant, where two issues were formulated. The argument on the two issues have been captured in the body of the judgment, so I will skip reading the argument. There is also the submissions of the unreasonable course of action. There is also the submissions of the claimant, where three issues were formulated. The argument on the three issues have been captured in the body of the judgment, so I will skip reading the submissions of counsel. I now go straight to the decision of the court. I have considered the processes filed by the parties in this suit, the evidence laid at the trial, as well as written and oral submissions of counsel for the parties. To my mind, the issue calling for resolution in this case is whether, having regard to the evidence by the claimant, he has proved entitlement to any of the relief sought. The facts that necessitated filing this suit are straightforward and not much in dispute. From the pleadings and evidence before the court, the claimant, Engineer Solomon Olorufemi, was employed by the defendant Lafarge Africas PLC or its predecessor Unichem. The claimant's employment relationship with the defendant commenced as a mechanical instructor, which spanned for the period from 3rd day of June 2013 to 4th day of May 2023. The claimant served in 3 distinct capacities during his employment, including mechanical instructor, lecturer 2, and rector/principal lecturer. The claimant retired from the service of the defendant on the 4th of May 2023 or reaching the age of retirement and received his terminal benefit. The claimant relying on Exhibit C2 and C3 now approach this court to claim remuneration for 2 out of the 3 distinct capacities he said he served the defendant, i.e., the role he served from 15th day of December 2014 as lecturer 2 and from 16th day of July 2016 as rector stroke principal lecturer. By his originating process, the claimant is claiming entitlement to all remuneration and benefits attached to the 2 letters of appointment, Exhibit 2 and Exhibit C2 and Exhibit C3 respectively. The defendant, while admitting claimant worked during this period, disputes the validity of the claims for unpaid remuneration and benefit for the lecturer 2 and rector principal lecturer roles, arguing that the claimant accepted full and final settlement of all entitlement upon retirement. The claimant is stopped from making any other claim subsequently against the defendant, as the claimant had by the Exhibit XS 3B forfeited and waived any right of claim against the defendant. The core dispute, which this court is saddled with the responsibility of resolving, is whether the claimant is legally entitled to specific outstanding remuneration and benefit claim for the period corresponding to the post of lecturer 2 and that of rector stroke principal lecturer appointments, despite signing a full and final settlement document, Exhibit XS3B. Furthermore, the claimant seeks payment of 51,009,750 naira as basic salary, and also he claims 38,436,801 naira as allowances due to him covering the period from December 15, 2014 till May 2023, arguing that the defendants unlawfully refused to make the said payment to him. The defendant contended that the claimant is stopped from claiming these specific sums because on June 6, 2023, the claimant signed an acknowledgement, Exhibit XS3B, accepting the payment breakdown Exhibit XS3A as full and final settlement of all entitlements, thereby releasing the defendant from all the claims arising out of his service. The facts in dispute is whether the claimant's signature on the full and final document legally bars him from pursuing the specific monetary claims for unpaid salary and allowances dating back to 2014. The claimant also seek an order compelling the defendant to issue a certificate of service specifically for the role of rector principal lecturer. The defendant asserts that a certificate of service was issued to the claimant on June 5, 2023 as part of terminal benefit package, Exhibit XS3A. The dispute centers on whether certificate of service issued adequately reflects the claimant's service as rector stroke principal lecturer, or if a separate specific certificate is required and legally due. However, before delving into the determination of the claimant's claim, I shall endeavor to deal with preliminary objection raised by the defendant on alleged non-disclosure of a reasonable course of action by the claimant. This is a fundamental issue that deserves to be first dealt with before proceeding with the measure. Both the defendant and the claimant have in their addresses advanced argument for and against the alleged non-disclosure of a reasonable course of action. I have herein before captured the argument of counsel on this issue as argued in their respective written addresses. Suffice to say that the defendant is of the view that the claimant's action is devoid of a reasonable course of action, while the claimant is of the view that the case of the claimant is properly before the court and has disclosed a reasonable course of action. In determining whether there is disclosed a course of action or a reasonable course of action, the court has to look at and consider the facts as pleaded in the statement of claim or facts filed by the claimant on which the claims made are predicted. In other words, the only relevant document a court has to or need to consider or look at to determine whether a course of action or reasonable course of action exists or is shown to exist is the statement of facts, i.e. the pleadings of the claimant, which contain all the facts relied on by the defendant in making a claim against a defendant and seeking judicial remedy from the court. See the case of Anyaboye versus Balogun, Fumodo versus Agoro, Onadeko versus UBN, and host of other cases cited therein. Under the Nigerian law, a reasonable course of action must reveal some facts, which, if proved, will entitle claimant to the relief sought. From the pleadings of the claimant, his claim borders on claim for unpaid remuneration based on alleged upgrade in the employment position to lecturer 2 and rector/principal lecturer. The basis of the claim is Exhibit C2 and C3, which are the letters of employment for the post on which the claim is being made by the claimant. According to the claimant, he had not been paid the remuneration for the two posts despite having served the duties of those posts. It is clear to me from the pleadings of the claimant that he has disclosed a reasonable course of action against the defendant in this case, more particularly taking into consideration paragraphs 1 to 3 of the statement of facts, coupled with Exhibit C2 and C3 respectively. The claimant is also claiming that the certificate of service issued to him did not state or reflect the correct designation and position held as at the time of retirement from service of the defendant. The argument of the defendant that the claimant, having claimed to have worked for Unichem Community Initiative or to have joined Unichem as a party, cannot assist the case of the defendant for the simple reason that if there is such a failure, it will not amount to it will only amount to non-joinder, which will not affect the validity of the suit on ground of alleged non-disclosure of reasonable course of action. In any event, the court has a bounden duty to determine liability of parties before it appropriately. In the case of Thomas versus Oluposoye, the Supreme Court gave the meaning of course of action a reasonable course of action per Obaseki JSC of blessed memory as follows. I will pause at this stage to look into the meaning of course of action. The definition appears in the White Book. I will refer to the 1976 White Book, the Supreme Court Practice, Volume 1, page 161. There, the meaning of course of action as stated by eminent judges in England and Ireland is given as follows. 1. The word course of action comprises every fact, though not every piece of evidence, which it would be necessary for the plaintiff to prove if traversed to support his right to the judgment of the court. See Reed versus Brown. Followed Asher M.R. 2. The phrase comprises every fact which is material to be proved to enable the plaintiff to succeed. See Cook versus Gill. Brett J. Number 3. The word have been defined as meaning simply a factual situation, the existence of which entitles one person to obtain from the court a remedy against another person. Per Diflock LJ in Letang versus Kufa. On meaning of reasonable course of action, His Lordship went on to state, what then do the phrase no reasonable course of action means? There is some difficulty in giving a precise meaning to this term. In point of law, every course of action is reasonable one. See Fachiti J, a ref of Peru versus Peruvian Guano. Lord Piercy in Drummond Jackson's versus British Medical Association define reasonable course of action as meaning a course of action with some chances of success when only the allegation in the pleadings are considered. The practice is clear so long as the statement of claim or the particulars disclose some course of action or raise some question fit to be decided by a judge or jury. The mere fact that the case is weak and not likely to succeed is not a ground for striking it out. Moore versus Lawanso, where the statement of claim disclosed no reasonable course of action, and if the court is satisfied that no amendment, however ingenious, will cure the difficulty, the statement of claim will be struck out and the action dismissed. Where no question as to civil rights and obligation of the plaintiff is raised in the statement of claim for determination, the statement of claim will be struck out and the action dismissed. It is clear from the above definitions of course of action and reasonable course of action, although the claimant is required to do in law to have course of action, a reasonable course of action is to raise some question fit to be determined by a judge or a jury. Once it is done, the mere fact that the case is weak and is not likely to succeed is no ground for striking out. In the case at hand, there are questions that need to be answered. There are questions that need to be answered. The claimant is claiming for remuneration for service rendered. In labor law, remuneration is a right of an employee, which the employer is duty bound to pay. By his claim, the claimant has shown that the remedy he is seeking from the court is based on the right or entitlement to be paid paid for service rendered. This has in no doubt This has no doubt established existence of a course of action and a reasonable one for that matter. I have carefully and painstakingly considered the pleadings before me, and I am satisfied the claimant in this case, by his pleading, has disclosed a reasonable course of action. The objection of the defendant on non-disclosure of reasonable course of action failed, same is hereby rejected. Coming to the determination of the case, as presented by the claimant, the issue calling for resolution is whether the claimant has, by the evidence adduced before the court, proved entitlement to any of the relief sought. The law is settled that he who asserts must prove. In the case at hand, the claimant being the one that asserts entitled to be paid remuneration for the two posts on which he served, the defendant and entitled to having certificate showing that his last position, which the defendant was rector his last position, which was rector stroke principal lecturer, was the appropriate position on which such a certificate should be issued. The onus of proving this assertion lies on the shoulders of the claimant. For the court to enter judgment in his favor, the claimant must adduce sufficient, credible, admissible evidence in proof of his claim before the court. It is when the claimant has discharged the burden of proof imposed on him by law that the burden will shift to the defendant. See section 131, 132, 133, 134, and 136 of the Evidence Act as amended. See also BP Industry Limited versus Cocoa Industry Limited. See also Paje Mirocon versus GB Nigeria Limited and Egareba versus Osagi. The crux of the claim of the claimant is for payment of outstanding remuneration and benefit for the period the claimant served as lecturer 2 and rector, principal lecturer respectively. The evidence relied by the claimant in proof of his entitlement to the accrued remuneration for the service rendered by him as lecturer 2 and rector stroke principal lecturer is exhibit C2 and C3, which are the letters of appointment to the respective posts, which also contains the remuneration. He also relied on exhibit C4, C5, C6, C7, C8, C9, C10, C11, C12, C13, C14, CR1, C, and CR2 to show that he worked for the defendant in line with exhibit C2 and C3, which are the letters appointing him to the position of lecturer 2 and rector stroke principal lecturer. The defendant, despite admitting that the claimant being her employee, and despite having admitted the claimant served the defendant from 3rd day of June 2013 to 4th day of May 2023, when he retired from the service for having clocked the retirement age in service of the defendant, and despite paying the claimant his terminal benefit, is still denying services rendered by the claimant to her as per exhibit C2 and C3. By the denial, the defendant seems to be inconsistent in its presentation of her case. In law, a party is required to be consistent in presentation of his case before the court. The defendant, having admitted claimant to be her employee and having admitted the claimant served her from 3rd day of June 2013 to 4th day of May 2023, when he retired from her service and paid his terminal benefit, cannot be heard to change its position by contending that the claimant did not serve the defendant. In the case of Daniel versus Anek, the apex court FAPA-B JSC has this to say on the subject of consistency in presentation of cases. I quote, a party should not be inconsistent in the presentation of his case in court. No reasonable court can do anything to assist such a slippery claimant. His lordship refers to the case of Ajide versus Klani. In law, consistency is one of the hallmarks of truth. See Governor of Lagos State versus Ohio Nigeria Limited. See also Akino versus Interim. See also Ijomone versus Omonibo and Maiturare versus Saidu. The claimant has by the paragraph 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, and 19 of the statement of facts, as well as paragraph 7, 8, 9, 10, 11, 12, 13, 14, 16, 17, 18, and 19 of the witness statement on oath and the exhibit tendered in support, being able to establish his appointment as lecturer 2 and rector stroke principal lecturer 2. He has also been able to prove that he performed his duties attached to those positions as per exhibit C3, C2, and C3. This means the claimant has discharged the onus of proof imposed on him by law as per section 131 of the Evidence Act as amended. The defendant on his part, under cross-examination, tenders through CW1 exhibit XS1, which the claimant admitted it was issued to him by the defendant. He also admitted signing it. The defendant has insisted in both final written address and the reply on point of law filed on 12th day of November 2025 that the claimant, having accepted payment of his terminal benefit as full and final payment, has no right to make any claim from the defendant, as by making the claim, the claimant is challenging the termination of his employment. Once employee accepted terminal benefit and executed a discharge certificate acknowledging full and final payment, he is stopped from making any further claim relating to the said employment, as the claimant by his conduct has waived the right to reopen his matter. Let me quickly say that contrary to the position taken by the defendant, there is no relief among the reliefs being sought by the claimant that is contesting validity of termination of his appointment. In fact, the claimant's employment was never at any time terminated by the defendant. I do not know why the defendant is making frantic effort to smuggle into the claimant's claim issue of termination of employment. I have examined all the cases cited and relied by the defendant in reply on point of law. They are not on all fours with the facts of this case. The principles of those cases seems to project borders on whether an employee who had been paid his terminal benefit can turn around to contest validity of termination of his employment. In the case at hand, there is no termination and there is no contest of validity of termination. What is before the court is entitlement to remuneration and allowances. From Exhibit C1, the claimant serves the defendant as mechanical instructor from 3rd day of June 2013 to 28th day of February 2015, from 1st day of March 2015 to 31st day of December 2015. The claimant serves the defendant as lecturer 2 from 1st day of January 2016 to 3rd day to 30th June 2018. The claimant serves the defendant as a mechanical instructor again, while from 1st day of July 2018 to 4th day of May 2023, when the claimant finally retired from service, he serves the defendant as rector / principal lecturer. See Exhibit C1, C2, XS1, and C3. The counsel for the claimant in his submission has insisted that the claimant had only 3 letters of employment, Exhibit C1, C2, and C3, and no more. However, under cross-examination, Exhibit XS1 was tendered through the claimant, and this letter was another letter appointing the claimant to the position of mechanical instructor with remuneration different from the remuneration contained in Exhibit C1, which appointed the claimant on the same position. But the claimant chose not to make any claim based on Exhibit XS1. With Exhibit XS1, which claimant has admitted having been served with, it means the appointment of the claimant to the position of mechanical instructor was made twice. This also shows that the claimant served as mechanical instructor from first day of January 2016 to 30th day of June 2018 for the second time. The revelation from Exhibit XS1 also goes to show that the claimant has no any claim in respect of said appointment. It also shows that for the period covering first day of January 2016 to 30th day of June 2018, the claimant has no any claim against the defendant, since the letter explicitly stated that the new employment was as a result of integration of Lafarge and Holcim entities in Nigeria, and it supersedes any previous employment with any of the legacy business. The defendant primary defense rests on the doctrine of Estepel and Weber, arguing that by signing and accepting itemized terminal benefit as full and final payment of all claims, whether known and unknown, the employee is precluded from making further claims. In Nigerian law, Estepel prevents a party from asserting a claim or right that contradicts a previous statement or action, especially when another party has relied on that statement or action to their detriment. Waiver, on the other hand, is a voluntary relinquishment or abandonment of a non-legal right or advantage for a waiver to be effective. It must be shown that the party waiving the right did so voluntarily, unequivocally, and with full knowledge of the rights being waived. Now, the issue to be resolved on outstanding remuneration of the claimant as per Exhibit C2 and C3 revolves around the legal effect of the claimant alleged acceptance of full and final settlement as per Exhibit XS3B. This court is now saddled with the responsibility of determining whether the claim of outstanding remuneration and benefit accrued during the claimant's service as lecturer to a rector stroke principal lecturer has been negatively whittled down by Exhibit XS3B, showing the claimant has accepted the benefit itemized in the said document as full and final settlement of any claim he has against the defendant. In matters concerning settlement agreement, the law requires that there must be a clear and unequivocal agreement between the parties, supported by consideration to compromise existing dispute where a party accepts a sum stated to be in full and final settlement. It generally implies a waiver or further claims against to the subject matter of the settlement, provided the settlement itself was validly entered into and not procured by fraud, misappropriation. The claimant, having served in various capacities, is claiming entitlement based on those roles. The defendant relies on Exhibit XS3B as a bar of those claims. There are several documents tendered by the parties to support their respective position. I have thoroughly examined all the exhibits tendered by the parties in this case. This is because in law, documentary evidence is regarded as vital and superior to oral evidence. This is so because while a witness may lie and his evidence may not be accepted, documents, it is said, do not lie, and once properly received, the court is bound to act upon it. In the case of FATB Limited versus Partnership Investment Limited, the Supreme Court per Igu JSC emphasized on the importance of superiority of documentary evidence and stated that documentary evidence, where it is relevant, ought to be produced and tendered as they speak for themselves as against the ipse dixit of a witness, which may not be readily accepted by the court. See also Bond Limited versus Saleh. See Section 132, subsection 1 of the Evidence Act, Laws of the Federation. See also FBN versus May Clinic. That's why documentary evidence is used as hanger from which to test the veracity of the evidence, whether oral or by deposition. It is also settled that it could be used to resolve issues or conflicting evidence as documents speak for themselves. See Obileve versus Adingi, see Oduche versus Oduche, see also Bunge versus Governor of Rivers State, see also Essien versus Etokudo. I note that the claimant is only on terminal benefit. On terminal benefit, but on unpaid remuneration and allowances for services rendered to the defendant. This means the alleged waiver This means that the alleged waiver or compromise arising from acceptance of full and final settlement in the context of outstanding contractual entitlement does not arise by signing of Exhibit XS3B by the claimant. The law is right and consistent that a waiver must be clear and unambiguous. The claimant's claim is for unpaid remuneration for services rendered, which is distinct from calculation of terminal benefit as per Exhibit D1 and XS3B, while terminal benefits are typically calculated based on an employee's service and remuneration as per the terms of employment or company policy. A claim for unpaid salaries for work already performed constitutes a fundamental breach of employment contract regarding wages. The case of Ulegede and another versus military administrator Benue State comes to mind. This case emphasizes that an employee is entitled to benefit or entitlements that are accrued before the dismissal or termination. The principle suggests that earned wages are a fundamental entitlement. The question then becomes whether a general, full and final payment clause in a terminal benefit document can extinguish a claim for specific unremunerated services rendered by claimant to the defendant. Exhibit C2 and C3 are clear and unambiguous. They say what they say. By this exhibit, claimant was employed as lecturer 2 and rector stroke principal lecturer. By the exhibit C4, C5, CRC2, the claimant performed the duties of those office, but he was not paid or remunerated. As per exhibit C2 and C3, the defendant attempted to claim that the claimant did not serve the defendant, but served Unichem. However, this assertion has been whittled down by the admission of the defendant that claimant was her employment and served from 3rd June 2013 to 3rd June 2023. The exhibit tendered by the defendant D1, D2, D3, D4 in support of the case of the claimant be served It is clear to me failure by the defendant to pay claimants appropriate remuneration as per Exhibit C2, C3 is a clear abdication of responsibility as employer is duty bound by law to pay his employee his retirement, his remuneration as per an The claimant has admitted receipt of terminal benefit as tabulated and itemized in Exhibit in Exhibit 23B. Therefore, thereafter, his counsel wrote letter of demand of his unpaid remuneration on his instruction to the defendant. However, the defendant stated that the claimant did not protest the payment contained in Exhibit C XS3B. Rather, he collected the said payment as full and final pay. Now, can it be correct to say that the claimant, when presented with Exhibit 33B, and he was required to sign it before he was paid at that time. The claimant, as at the time of giving Exhibit XS3B, he was concerned with terminal benefit, the subject of the said exhibit is in circumstance I strongly believe the claimant, as at the time of signing Exhibit XS3B, he was concerned with terminal benefit, the subject matter, the subject of the said exhibit in the circumstances. It would be unfair to include unpaid remuneration, which is separate, distinct from terminal benefit. As pointed out earlier, the reliefs claim relate to the earned salaries and unpaid allowances and not payment of incorrect benefit. The mere fact that the claimant collected the benefit The mere fact that the claimant collected the benefits that were computed and paid to him by the defendant as his final entitlement cannot stop him from challenging the non-payment of unpaid earned salaries and allowances for work done. See the Court of Appeal decision in the case of Panabis International Limited versus Adidong Nigeria Limited. It is to be noted that the claim for unpaid salaries and allowances are such claims that the law allows an employee to claim either a situation of termination or dismissal from service. See Odubanam versus FCDA. In a claim for wrongful termination of appointment, an employee can also claim for salaries, leave allowances, etc., earned by the employee but not paid by the employer at the time of termination. The important thing is whether the claimant is able to sustain his claim. To hold otherwise would amount to allowing the defendant to practice fraud on the claimant. Estoppel cannot be allowed The important thing is whether the claimant is able to establish his claim. To hold otherwise would amount to allowing the defendant to practice fraud on the claimant. Estoppel cannot be argued where issue of fraud is or illegality is concerned. See Nuntung versus Long Kwang and others. See also Attorney General of Bendel State versus Attorney General of the Federation. It would be plainly illegal, fraudulent, and unconscionable to allow the defendant to rely on estoppel to prevent the claimant from proving entitlement to unpaid remuneration or services rendered simply because he collected After all, there was no evidence of any negotiation leading to the purported full and final payment to warrant the argument from the defendant that the signing of Exhibit XS3B by the claimant amount to acceptance of what was stated in the exhibit as full and final payment. thereby waiving his right of making any claim in respect of services rendered to the defendant. The most elementary principle of contract is that agreement precedes contract, and there was no such agreement that was shown to have preceded the agreement. It is pertinent to stress here that for Exhibit XS3B to have any impact on the claimant's case, consideration is vital to any agreement. In this, the contract relied upon was merely worthless, the said exhibit is a mere worthless piece of paper having no any legal effect for lack of consideration. For this reason, the action of the defendant in making the claimant to sign exhibit excess 3B amount to unfair labor practice, and that the purported execution of the purported contract was evidence of bad faith on part of the defendant. It also shows that for the period the claimant worked and served the defendant only want to take benefit of claimant's services, but had no intention of remunerating the claimant with commensurate to the service rendered to the defendant. This is an injustice no court of law or equity will allow. It must also be noted that the mere fact that an employee accepted the payment of a lower accepted payment of a lower entitlement does not disentitle him from what rightfully belongs to him. He can claim the difference in an action as the claimant is doing in this case. From all I have been saying above, the issue of estoppel or waiver are not of any moment, as the defendant wants the court to believe. In view of this finding, I came to the conclusion that the claimant is entitled to claim unpaid remuneration and allowances commensurate to the services he rendered to the claimant as lecturer 2 and rector stroke principal lecturer 2 respectively. Now the task to be performed is to determine whether claimant has proved entitlement to the sum of 51,750 naira. In law, claim for basic salary and allowances being monetary in nature are claim for special damages, which is a law imposes a duty on the claimant to specifically plead, particularize, and prove strictly by cogent credible evidence. I have scrutinized the claimant's pleadings as well as the evidence in chief and under cross-examination. What emerges is that the claimant failed to particularize the salaries and allowances being claimed, despite stating the period of which this significant fatal default. Under the Nigerian jurisprudence, for a claimant to succeed on his claim for special damages, he must be able to do so by strength of his case, by showing how the amount being claimed was calculated and the lump sums arrived at. He must do this by showing breakdown of the claim by parties, the salary scale applicable to each post. He must also be able to show difference the salary scale applicable to each post. He must also be able to show the difference amount unpaid. This is because by his paragraph 11, 12, and 18 of the statement of facts, the claimant has stated that he was not paid entitlement in compliance with figures and terms of employment as per Exhibit C2 and C3. As according to the claimant, the defendant continued to place him on his remuneration as a mechanical instructor. It is only when claimant has supplied necessary sufficient particulars that the defendant was not able to properly respond. The court would also be in a position to assess the value and evaluate the claim of the claimant with a view to verifying the calculation and entitlement of the lump sums if paid, facts and figures to enable the burden of establishing entitlement to the basic salary and allowances as per claim of the claimant is on the claimant. The claimant must prove exact basic salary as per salary scale for each of the position held, which he The claimant must prove the exact basic salary as per the salary scale of each of the position held to which he claims basic salary and allowances, what he was actually paid versus what should have been paid that was not paid. This will enable the court to know the actual deficit of the payment of the basic salary and allowances. The lump sum being claimed without particularization, showing monthly salary for each post held, lack of calculation of arrears on monthly basis for each position, and lack of any documentary evidence showing the basic salary and allowances have already exposed the absence of proof of the special damages. In claim for special damages, pleading must contain sufficient particulars to enable the opposing party to understand the case they are to face. This is fundamental requirement of fair hearing and due process. The rules of this court mandate that a claimant must provide sufficient details of their claim, including how the sums being claimed was arrived at. Without particularization, the defendant cannot effectively challenge the quantum of the claim, and nor can the court properly assess the merit of the claim. See Agomo versus Fidelity Bank. In this case, the Court of Appeal highlighted what court should consider in determining entitlement of an employee, which include letters of employment, pay slips, etc. The effect of failure to present same is fatal to the claimant's case. In this case, the claimant, apart from Exhibit C2 and C3, did not tender his pay slip or pay slip of his colleagues on the same grade level to show that it is salary or in view of the absence of what was paid to the claimant as a mechanical instructor for the period of the claim, and what the claimant is entitled to as lecturer 2 and lecturer and rector stroke principal lecturer, and for the court to find the difference by subtracting what was paid from the entitlement of the claimant for the period he is claiming remuneration, the court will not be in a position to come to any conclusion as to what the claimant is actually entitled to as his unpaid remuneration. The court will not be justified to grant claimant's claim in the absence of proper particularization and strict proof. The court cannot speculate on earnings of the claimant. To plead and without strict proof means no proof. The reliefs are not supportable by primary facts or evidence. A lack of particularization is a defect that has originally weakened the claimant's case. Irrespective of the findings, irrespective of the finding that he is entitled to claim for unpaid remuneration or unpaid allowances. The reason being that for the claim on salary and allowances to succeed, they must be proved by cogent, admissible evidence. Since they are monetary in nature, they are special damages. Therefore, the failure of the claimant to particularize the sums being claimed as salaries and allowances is a serious blunder fatal to the claim. The court will not be in a position to entertain a claim where the basis of the calculation is not clearly laid out, even if the substantive claim for unpaid wages is strong. See AG Oyo State versus Fair Lake Hotels. See also Charles Odubanan versus FCDA. The obligation to particularize a claim for special damages arises not because of the nature of the loss is necessarily unusual, but because a claimant who has the advantage of being able to base his claim on a precise calculation must give the defendant access to those facts which make him do such calculation. In this case, the claimant plead his claim In this case, the claimant pleaded his claim for special damages but failed to particularize. See FBN versus Associated Motor Limited. See also British Airways versus Atoebi. Special damages must only not be particularized but specially pleaded with relevant particulars, but must also be strictly proved with credible evidence. Without such proof, no no special damages can be awarded. In other words, any evidence, no matter how unchallenged, uncontradicted, which falls short of what is required to prove special damages must be rejected. In the instant case, the claimant lumped his claim for basic salary In such case, the claimant lumped his claim for basic salary for the period of claim without specifying which claim is for lecturer 2 and which is for principal lecturer. He has also lumped claim for unpaid allowances without specifying allowances for each of the posts. It is not the duty of the court to specify each item of claim. It is the duty of the claimant which he failed to discharge. The damages This means Release 24E tells same is hereby refused. See also Shell BP versus Call and Dumes versus Ubole, Agbaruka versus First Bank, or Relief 24F, which is for an order directing defendant to issue certificate of service to the claimant for rectorship. Certificate of service is usually issued to an employee to accurately reflect his record of service. To this end, his employer by the Exhibit 3, the claimant served as rector stroke principal lecturer from 1st January 2018 to 3rd of May 2023. Therefore, his certificate should reflect the correct position held as at the time of retirement. The claimant in this case is entitled to have his certificate of service to reflect his accurate position as at the time of retirement. This is because an employee has a legitimate interest in having accurate employment records, as this effort affects his future employment opportunities and other professional remuneration. In the circumstances, Rule 24F succeed same is hereby granted. The defendant shall issue another certificate of service to the claimant to reflect the position on which he retired from service. Relief 24G and H are for the sum of 10 million general damages for hardship, embarrassment, pain, and 10 million as it is clear these two reliefs, they are same. The amount are the same. They are all for hardship and suffering. However, this means they overlap. However, general damages are such damages that the law presumed to be natural or probable consequence of the Defendants Act need not be specifically pleaded. It arises by inference by law and need not therefore be strictly proved by evidence and may be abated generally. On the other hand, special damages is such loss as the law will not presume to be consequences of Defendants Act, but which depend in part on the special circumstances of the case. Special damages must be specifically pleaded and strictly proved. In this case, the respondent clearly, in this case, the defendant clearly and unequivocally, the claimant clearly and unequivocally pleaded special damages. However, there is no iota of evidence from the claimant in proof of the said special damages, as the said claim was not particularized and strictly proved as required by law. The obligation to particularize a claim for special damages arises not because of the nature of the loss is necessarily unusual, but because a claimant who was advantage of being able to base his claim on precise calculation must give the defendant access to those facts to also make calculation in respect of those claims. In this case, the respondent clearly and unequivocally pleaded his claim for special damages, but there was no evidence in proof. In the circumstances, relief for special damages failed, same is hereby refused. For reliefs I and J, they are for post-judgment interest and cost. In Nigeria, post-judgment interest and award of cost are usually at the discretion of the court. The court has discretion to determine the interest to be awarded and the cost to be awarded. Cost follow event need not specifically be pleaded, as the court has discretionary power to granting the said relief based on the assessment and not on what was claimed. In view of the foregoing, the claimant has partially succeeded in proving his case. For avoidance of doubt, the orders of the court are as follows. Relief 24, A, B, C, D succeed and same are hereby granted. Those reliefs are for declarations. Relief A for payment of the sum of 51 million 9,750 naira as basic salary, and the sum of 38 million as allowances due to the claimant from December till May fails due to lack of proof. Same, it, they are hereby refused and dismissed. Or relief F, relief F succeed. Same is hereby granted. The defendant is hereby ordered to issue a new certificate of service to the claimant reflecting his correct and accurate position when he retired from service. That is to show the post on which claimant retired from services of the defendant. Relief G is for claim claim to damages. The claimant, having succeeded in some respect, is entitled to damages. In the circumstances, I award 500,000 naira as damages to the claimant. The defendant is hereby ordered to pay the claimant the said 500,000 naira. Relief H failed due to lack of proof. Same is hereby refused. On cost, I assess cost payable by the defendant to the claimant to the sum of 300,000 naira only. Let me say before ending this judgment that this suit has exposed let me say before ending this judgment that in any event, full disclosure of facts and evidences is the only way for success for the parties. Parties are supposed to make full disclosure and not to hide anything from the court or from each other. It is unfortunate that Exhibit XS1 and XS3B were well known to the claimant, but he failed and refused to disclose until when he was confronted under cross-examination. This case has also is also a reminder that there is need for always counsel to be circumspect in drafting their processes, in making sure that what is required of them is done in order to succeed. I must state the failure of the parties in this case to make full disclosure and trying to play tricks on each other has played a significant role in the result, in the outcome of this case. Counsel as ministers in the temple of justice are required to honestly to be honest and make full disclosure, even if it is against their client. I say no more on this. Judgment of the court is hereby entered accordingly.
As the court please.
Well, my lord, I thank my lord for very erudite.
Yes, register, call the next case.
Yes, my lord. Suit number NICN CA 43-2025 between the Incorporated Trustees of Unical Chapel of Redemption and 1. Reverend Joseph Oshe, 2. Professor Austin David Oko, Chairman, Unical Chapel of Redemption Council. My lord, the parties are all here.
Okay. The parties are here. I defend that.
My lord, respectfully.
Is the parties present?
Yes, my lord.
Yes, my lord, the parties are all present.
Okay. Appearance.
If it pleases my lord, Dr. C. N.
Yes.
Kokelu. Dr. C. N. Kokelu for the claimant.
Okay. Yes, any other appearance?
Yes, my lord. With great respect,
Yes.
my lord, I am P.O. Arepo. My lord, humbly for
You
the
have
defendant.
to make yourself available if you want me to record you as present.
Sorry, my lord.
You have to make yourself available. You have to make yourself available.
Yes, my lord, I'm trying to do so.
If you want to participate in this proceeding.
Yes, my lord.
I cannot see you.
My lord, I'm trying to make my lord see me. Blessed. My lord is not seeing me.
You have to put on your camera. Otherwise, I will record you as absent.
No, my lord, I'm present, sir. I'm present.
You are not present as far as the court is concerned.
My lord, I'm trying to open the facility, sir. My lord, I'm seeing you very clearly.
I said I cannot see your face.
The court needs to see you. The court needs to see you. P.O. the court must see you.
My lord, are you seeing me now?
Yes.
My lord,
yes.
P.O. Arepo, humbly for the defendants on record, sir.
Yes.
Yes, my lord.
Yes, my lord. My lord, ordinarily the matter is for adoption. My lord, we were served, but ordinarily the matter is for judgment, but we were served a further counter affidavit by the defendant in support of their former counter affidavit.
Yes.
My lord, based on that, their counter affidavit, my lord, they had attached an exhibit from Corporate Affairs Commission 19.
Yes.
My lord, pursuant to that, we have written the Corporate Affairs Commission because such a public document should have been served on us. My lord, we don't know about such documents and we feel they are fraudulently, I don't know, my lord, is wrong to say it that way, but we want to authenticate. How
long will it take you to do that? This matter came up on 28th of January, and the same story that you want to authenticate. That's why we adjourned it to today for you to authenticate.
My Lord, we have written them. We wrote them, and they are yet to send any reaction to us. We have been going through, my Lord, we are doing the needful. My Lord, we will want a date maybe in second week of March, so that we'll be sure that by that time, they would have written us. My Lord, we have petitioned, we have written our own. They are yet to make any reaction to our letter. My Lord, that's the case. And we
Mr.
need that
Aripo.
document to
Yes, my lord.
reply such a counter
My lord,
affidavit.
Yes.
my lord, first, we take exception to the word documents are fraudulent. My lord, we take exception to that. And my lord should withdraw that. My lord, we are coming from
I think
sincere
counsel
hardworking law firm.
Mr. Aripo, counsel realized that it was wrong for
Yes,
her
my
to say
lord.
that, and she admitted it. She quickly corrected herself. So no need for you
As
to
a
make any fuss on it.
Thank you, my lord.
Yes, what is
My
your
lord,
reaction to her request?
sorry, my lord.
What is your
My
reaction to
lord,
her
we will be
application?
opposing the. Sorry, my lord.
What is your response to her application for adjournment?
My lord will be opposing that. But if my lord is minded, my lord will ask for cost. My lord, this is so because today's date was at the instant. My lord, the further counter traffic they talk about was set on them since on the 27th day of January, sir. They were set on them, sir. Today is the 10th day of February. Yes, my lord. They had the opportunity to write to a CAC or to have responded. If they are truncating the matter for today, or we can't go on at the instant, my lord, we ask for cost. Cost follows the event. My lord, we came physically, myself and my learned friend, and we're not told it's virtual. My lord, can we prepare for the matter? So if we're not going on at the instant, my lord, we have a 500,000 cost against them, sir. Against the claimant. My lord, cost follows the event. But my lord,
yes.
Sorry, my lord.
Yes.
But my lord, before all of this, sir,
yes,
we will seek your indulgence, we will seek your leave.
Yes.
To make use of the process filed on the 27th day of January 2026, sir.
You say what?
The counter traffic under consideration. My
yes.
lord, we are seeking my lord's leave.
Mr. Aripo,
So that
internet
council
seems to be
at the appropriate time to make use of. Sorry, my lord.
okay. Yes,
My
I'm
lord,
hearing you. I'm with you.
Yes, my lord. For your leave and blessing to make use at the appropriate time of the further counter traffic filed by the defendant on the 27th day of January 2026.
I'm sorry, my Lord, I feel that's a premature application.
And my lord, we draw strength from the rules of this court, sir.
Yes.
Order 5, Rule 6.2.
Yes.
My lord, we draw strength from Order 5, Rule 6.2 of this court that permit my lord to depart from the evidence act in appropriate circumstances for purpose of fair hearing and natural justice, sir.
Yes.
Yes, my lord. My lord, is our application.
Yes.
Yes, my Lord. My Lord, it is I don't know, it's actually funny that the defendants could actually ask for cost. My Lord, from the history of this case, they were not in court. We adopted our proceedings, and this matter would have long been terminated with the judgment of court. My Lord, long after they were served with the processes and everything, and they were not in court, they filed an application to vacate the hearing, which had already long been done. My Lord, we allow them without asking for cost. My Lord, the documents, we did fresh adoption. My Lord, after
Yes.
the court has adjourned again for judgment, this is the second time. My Lord, this is their second attempt to arrest the judgment of court. They quickly filed a counter affidavit. My Lord, now, on their own part, this counter affidavit is premised on the petition they claim they wrote in August 2025, of which they said they claimed they got a reaction in January. My Lord, that's over 4 months. My Lord, on serving us such a counter affidavit, we have just put up our own letter, my Lord, which is not even up to a month.
Yes.
They took all the time without paying cost. And now, at the point that we want to, my Lord, for the justice of the case, it is important that we make our own letter and get a hearing from the Corporate Affairs Commission. My Lord, now they want a process that was not even to go in immediately without we making our phone. My Lord, we need to make a reaction to that counter affidavit. And such our reaction can only come if we have heard from Corporate Affairs Commission. My Lord, they issued us the certificate of incorporation. Then, without notifying us of anything, they are withdrawing it. My Lord, we need to be aware. My Lord, that's all we are asking. That's the justice that my learned friend is asking for. And I believe that this court is the only proper forum to get this justice. My Lord, we are good.
My Lord, my Lord, my learned friend reaction is misplaced and misconceived. Yes, totally misconceived and designed to mislead the court. My Lord, the purpose of today, we can't go on at their instance. That is the issue. And we are saying that if we can't go on at their instance,
Mr. Aripo,
yes, my Lord.
Let us not waste time. I have listened to all of you.
As the court pleases.
We don't need to continue to belabor the issue.
As the court pleases. My Lord, I'm able to what answer. I'll give up to you. All right.
Registrar, give me that. Registrar. Registrar,
My lord.
give me that.
My lord, the date in March.
Yes.
Okay, my lord. My lord, March 5.
I'm so sorry, my lord. My lord, March 5 is not convenient, my lord. My lord, if my lord can give us middle of March, so that we will not come the next
Agree on
again.
a date. Agree on a date. I said agree on a date. You and Arifo.
Chief Ari.
Yes, I'm hearing you. You say 5 is not coming up.
No, 5 is too early. We'll get a letter. What of 19th March?
19th. I say 15th. Yeah?
15th. 15th is fine.
15th is okay for you?
Yes.
Okay. Inform the court now. If it's coming up for
Well, can we come back on the 15th day of March?
Okay. It's
When?
all right.
My lord, we are very grateful. 15th of March, 2020.
Registrar, 15th of March, is it convenient?
15th of March is a Sunday.
My lord.
Okay, sorry. I was looking at 16th.
Let's do it on 19th.
19th. Aribo 19th now.
Yes, 19th
No, my lord.
March.
My lord, 19th is a holiday.
19th is a holiday.
Yes.
Okay, guide Victoria, guide us. Guide us. What of what of 17? Hello?
17th is not
My lord,
convenient.
Registrar, give me date, convenient date.
Yes, my lord.
18th
My lord,
March.
March 10th.
Yes, you come back on 10th of March.
As the court pleases.
What date?
March 10th of March.
As the court pleases. My lord, we
I
are
have
much obliged. My lord.
I have listened attentively to submissions of counsel for both sides on propriety or otherwise of granting an adjournment at this stage, and also granting leave to the defendant to use further counter affidavit as appropriate in this case. As things are, I am of the view that the claimant should be entitled to be given one more indulgence so as to enable them verify whatever they want to verify and file the response to the further affidavit, if any. For the further counter affidavit, leave is hereby granted to the defendant to make use of it as appropriate in the course of the proceeding. The claimant is also given 2 weeks from today to file a response, if any, to the said further counter affidavit. This case is hereby adjourned to 10th of day of March 2026 for hearing.
As the court pleases.
Thank you, my lord. My lord, we've not seen for the year. Happy New Year, my lord.
Thank you very much. I wish you same.
Thank you, sir.
Any other matter, Registrar?
No, my lord, that's all for today, my lord.
Okay, thank you very much, Counsel. We have come to the end of today's proceeding.
Hello, I don't know if my lord can hear me. Hello. Hello, my lord. I don't know if my lord or the court can hear me.